Welcome to Environmental Law course, dear learner and viewer. Today we are going to deliver the lecture on constitutional dimension of environment protection in India. Dear learner and viewer, you can vividly recall the last two lectures about the constitutional dimension of federalism, wherein we discuss about the India's federal character and the framework, and we have noticed that what kind of federalism is applicable to Indian constitution and what kind of the federalism is more soothing and sobering for the environment protection and sustainable development in India. We have compared and contrasted the centripetal tendencies of Indian federalism with that of the centrifugal tendencies of Indian federalism, and we reached to the conclusion that not one size fits to all, and it depends on the circumstances and the context of the environmental problems and planning that we must have centripetal and as well as centrifugal tendencies, and we must try to accommodate the centrifugal inputs in India's environmental protection and sustainable planning. With the lectures which we had about the sustainable development and environment protection in relation to the Constitution of India and federalism, now we are moving to the constitutional dimensions of environment protection in India, and we will try to see that how Indian constitution, which boasts to be one of the lengthiest constitution in the world, happens to engraft the provision of environment protection and sustainable development. How the Constitution of India is going to recognize right to life and personal liberty and try to see and insert that right to wholesome environment and ecological balance also fits into the purview and pale and ambit and scope of Article 21. We will also see that what has been envisaged under the Fundamental Right, Chapter 3 of the Indian Constitution, what has been envisaged under uh, the Chapter 4th of the Indian Constitution, which talks about the directive principles of a state policy, and what has been permeated under Chapter 4A of the Indian Constitution. We are in a comfortable position to discuss and dwell on the issue of the constitutional dimension of environment protection simply because we have already taken two lectures on the entire lawmaking process, environmental planning, environmental lawmaking, environmental legislative activism, be that in reference to the 7th schedule, be that in reference to the union list, be that in reference to the concurrent list, be that in reference to the state list, be that in reference to the 11th schedule, be that in reference to 12th schedule of the Indian Constitution. Here in this lecture, we will try to see that how environment have been perceived under the constitutional foundation in India. In this respect, what we feel that the Constitution of India 1950 elevates environmental protection to the high national goal through its provisions of fundamental rights, number one, number two, the directive principles of state policy, and fundamental duties, number three. With these, it tries to establish a kind of a legal and constitutional canopy which undertakes the entire legislative and institutional framework for environmental governance. And this constitutional canopy is important to see that how the environmental governance are going to be pursued in the federal structure, sharing the power, dividing the power between union, state, municipal corporation, and panchayati raj institutions, which we have seen in the last two lectures. We'll be looking at directly to what we can say is the directive principles of a state policy and the fundamental duties. Why? Because there are two 42nd constitutional amendment which tries to insert Article 48A and Article 51AG into India's constitution. And therefore, what we see that the directive principles of a state policy under Article 48A and Article 51AG, the fundamental duties, meaning thereby that these provisions are the mirror image and the twin towers on which we can have some kind of a bridging of the environment protection and as well as a sustainable development. What it tries to see that it not only say about the protection, but it also tries to improve. So one and two both are important and both have its relative merits to see from a different lens of the environment protection and sustainable development. And it tries to see that all these values of Article 48A and 51AG, one to the state, one to the citizen, can go parallel, concurrently, to see that how it is embedded the ecological responsibility in India's constitutional ethos and constitutional governance. We will try to see that how the fundamental right which has been described in chapter 3 of the Indian Constitution, most notably Article 22. However, Article 14 and Article 19 is also important because it confers certain freedoms and it tries to see the equal equality before law and the equal protection of law. How the interpretation of Article 14 has given rise to the notion of intergenerational equity, and how the freedom which has been enshrined into Article 19 of the Indian Constitution, be that the freedom of trade, business, profession, then how the competing interest of the industry and the environment are going to be synergized in the constitutional framework. We will also see that how the legislative competence of the constitution in distribution of the power has been one of the most important area to gain greater autonomy and authority of the constitutional mechanism and environmental issues and environmental governance, although this part has been the part of previous two lectures which we have just concluded before you. Now we'll try to see that how this constitutional context, that means the spirit of the constitution, permeates into environment and natural law resources. There is no two thought about it, as we have perused the seventh schedule of the Indian Constitution, and the seventh schedule has a long list of the entries relating to the environmental conservation and sustainable development and planning. So what we see that the Constitution of India elevates environment protection to a high national level of the national policy and planning. It distributes the power of the environmental governance between the union, states, as well as the municipal corporations and panchayati raj institutions. It also tries to see that how the power in relation to the state and as well as the citizens go hand in hand, and it also tried to exaggerate about the entire mechanism of the environmental governance by amplifying the role of the center, by amplifying the role of a state, by amplifying the role of municipal corporation and panchayati raj institution, along with certain constitutional bodies which has been created to resolve interstate dispute by the interstate council in relation to the water sharing, in relation to the dispute among the states on the question of environmental law and policy. Then, under the constitutional aspect of what we can say the constitutional dimension of environment protection in India, we'll be looking at the very point of what we suggest to mean that the scope, the constitutional history in India also bears enough testimony about the environmental protection, because in the constitutional history which comes from the Constitution of India, which has been a kind of a logical extension of the Government of India Act. So we see that the Government of India Act and the Constitution of India both try to discuss the national environmental institutes which are required in terms of the global challenges and as well as the challenges of the colonial India, challenges of the independent India, and it tries to see that how despite an explicit absence of explicit textual mention about the right to clean environment, how the judiciary in India or the Supreme Court and the High Courts in India emerged and sprang up as a bulwark to confer the right to environment and sustainable development. We will also try to see that how the Constitution of India as a fundamental parchment and document sets the foundational values which governs the India, and it also tries to see that how the constitutional framework of the government defines the relationship between the state and citizen in matters of use and sustainable use and judicious husbandry of the environmental resources. The Constitution of India also deals with natural resources and try to see that in India the Constitution is supreme, neither the parliament nor the court nor the administration. So the administrative, legislative, the financial, the judiciary, all the pillars of the government, no one is superior. Here, the Constitution enjoys supremacy because all institutions are supposedly subservient to the Constitution. All the authorities and all the pillars of the governance of the Constitution and the governance in India derives life, breath, and sustenance from the Constitution, and Constitution confers the power. Therefore, the supremacy of the Constitution is established. So, the it can be applied impliedly to the environmental protection in India that all the authorities, even if the state happens to be the trustee of the natural resources, then that trust that of the state happens to be a mighty institution, enjoys the power, then this power is a kind of a trust, and a state will act as a trustee as well as it is subservient to the constitutional limitations, and they are subordinate to what is the foundational values which has been permeated in matters of environment protection. The limitation which has been imposed by the Constitution is very important in realization of the universal human rights and fundamental rights by the individual, and it also tries to see a kind of a very balanced approach between the state, and a state must not transgress its limit, and it tries to be more human centric, more right centric, and no state can be lethal, no state can be coercive, but the state must essentially focus on the welfare of the people and the welfareism. The constitutional provision in relation to the environment protection in India can be studied as fundamental right, can be studied as directive principles of state policy, can be studied as fundamental duties. And in this sense, as we have seen the federal structure, there is no need to reiterate those points, but what we will try to see that the Constitution of India, which has been codified and has been implemented and drafted, and we have our Trust of Destiny, and on 9/26 January have enacted this constitution, as given ourselves to this constitution. The broad goal of the constitution, as given in the preamble, is justice, social, political, and economic. And then this justice, equality, fraternity is very important, because justice alone will not go to achieve the goal of the egalitarian society, which the Ambedkar has talked about, the egalitarianism. And the constitutional goal is to establish an egalitarian society, meaning thereby it's a more right-based, and it tries to repudiate all kind of the discrimination. It has an impact in matters of environment, because it also confers that nobody should be discriminated, and nobody happens to be depository and depository of the environmental resources, and that environment should also not be taken as a metaphor of the power, but it should be taken as a metaphor of the trust. And that trust in the trusteeship is embedded into India's constitution. And then we will be focusing mainly on fundamental right, directive principle of state policy, and fundamental duties. In this reference, we will be talking about the much maligned, as some of the constitutional law writer has said, that the 42nd Amendment have been criticized because of some other amendment which have crept into the India's constitution. But most salubrious part of the 42nd constitutional amendment in 1976 happens to be the introduction of the environmental provision, which was not mentioned in the original constitution 1950. Here it remains to be said that original constitution 1950 does not have any kind of a provision. There are two things: provision relating to environment per se. Technically speaking, technically speaking, the word environment was missing in the under Indian Constitution in 1950. Although it might have peripherally recognized the environmental values, environmental duties, environmental stewardship, but the very word of environment was neither in fundamental right, nor in directive principles of state policy, nor in any of the chapters of the Constitution, nor even in the seven schedules, a very elaborate elaboration of the union, power of the union, power of the state, power of the state and union both. But it there are certain entities, and this is the reason that the Upendra Bakshi has said that the Indian Constitution was environmentally blind. It was environmentally blind. It appears to be something that a kind of an observation by Professor Upendra Bakshi that the original constitution, as we say, did not include any explicit provision. There are two things: explicit and implicit. So, was there any implicit provision? Yes, there were large provisions, large items of the environment: forest, wildlife, water, navigation, agriculture, fisheries, animals, wildlife. Large items were implicit into the Indian Constitution. But explicit provision, if you talk of the environment per se, the environmental protection, it was missing into India's constitution, and that's why it was said to be environmentally blind. But when we talk of the 42nd constitutional amendment in 1976, because in 1972, Mrs. Indira Gandhi, as the premier of this country, participated in the Stockholm Declaration, and where she have provided and posed a kind of an image of leading India into the third world environmentalism and the environmental leadership. And that kind of the speech which she delivered in the Stockholm Declaration may rightly be recalled, that the rich nation asks us to clean the environment, but how we can clean the environment when the people are living in abject poverty, where their own the existence are being contaminated? How we can ask that don't contaminate the river when the forest dwellers are not having means for livelihood? They cut the woods and make both the and well. How we can ask to conserve the forest for the forest dwelling community? So the competing claims of the poverty, the competing claims of the population, poverty, population, and as well as the resultant pollution, which is emerging as the three-piece challenges which hovered the Indian economy and the country as a whole. That kind of the sentiment which was echoed in 1972 by the Premier Mrs. Indira Gandhi, then we reached to the conclusion that the after that the Mrs. Indira Gandhi tried to constitute a committee, and that committee is known as ND Tiwari Committee. The first thing which she did, that ND Tiwari Committee, she is constituted, And the term of the reference of the N.D. Tiwari committee was to look at the status of the environmental law in India. And this committee, which was established soon after her return from the Stockholm Declaration, have given a very loud thinking that what remains the status of the environmental law. And then the committee submitted its report in 1980, but without waiting into the recommendations of the N.D. Tiwari committee report to suggest some kind of a reform in the environmental law, because the environment per se was neither in the constitution nor any kind of a law dealing with the all environmental problem was in this country. It was only came after the 10 years of the 42nd constitutional amendment in 1986 we had a law known as Environment Protection 1986. So neither environment as a subject nor environment protection law as an overwhelming and umbrella kind of a concern was there in the constitution and law, and that was the term of reference. But without waiting the recommendations of N.D. Tiwari committee report in 1980, then the Premier Mrs. Indira Gandhi at that time have inserted and introduced the Constitution 42nd Amendment. Although, so we can say that prior to 1976, there are two things which is there. One is that 1950 to 1976, yes, we can say what it is to environmentally blind. But after 1976 to 1980 and 1986, because 1976 is 42nd constitutional amendment, 1980 N.D. Tiwari committee report to suggest reform in the Indian environmental law, and 1986 that passing of Environment Protection Act. So this decade is important, 1976, 1980 and 1986. So what we see that the environmental provisions was introduced in Constitution 42nd Amendment, and it granted Parliament legislative authority to make national law on forest and the wildlife, which was taken from the state list to concurrent list, to discern some kind of the seriousness in relation to evolution of the environmental law, and as well as some deep sense of constitutionalism which were bereft. The constitution was devoid of any kind of the environmental concern. That concerns were introduced in 1976. With this, what we see that the directive principle state policy, which has been taken from the Irish constitution, and as it has been legally said that these directive principles of a state policy is not enforceable, but that does not hold ground in the late 80s of India, because the Indian Supreme Court, after the pronouncement of Maneka Gandhi versus Union of India, have revitalized the entire scope of the Article 21. Vis-a-vis, it reinvigorated fresh stamina into the non-justiciability of the directive principles of state policy, and tried to read directive principles of state policy, which has been said by the Dr. B.R. Ambedkar that these are directive principles of state policy, but they are fundamental in the governance of the country. So one set was the fundamental right, another set was fundamental governance of the country. The Supreme Court tried to read the fundamental governance and the fundamental right both together as a goal for governance in India, and have created its own jurisprudence to interpret the Article 21 to confer the environmental right. But here, what we'll be discussing that the change in the entire notion of non-justiciability to justiciability of the directive principle of state policy we'll be discussing in due lectures to come. But here we can suffice to say that the 42nd Amendment, Article 48A, which says that the state shall endeavor to protect and improve the environment and to safeguard the forest and wildlife of the country. So what is important here, that the duty is a state, whether a state is a trustee of all the natural resources, that is to be understood in the context of the fundamental in the governance of the country, as it happens to be legally speaking, dictate principle state policy, constitutionally speaking, is fundamental into the governance of the country. Now, what is fundamental? That the environmental governance itself is a fundamental, and the state shall endeavor to what is, this is very important, which Armin Rosenkranz, the textbook writer on environmental policy and law in India, have rightly pointed out that as rightly pointed out that this protection and improvement clause is one of the rarest clause in the constitution of the world, because most of the constitution of the world, as we have seen in the previous lecture when we discussed the comparative constitutionalism, constitutional perspective of the environment and sustainable development, where we had an occasion to discuss in quite detail that how the constitution of the world and more than two-thirds part of the world have amended their constitution and inserted environmental right as a matter of fundamental right, a matter of the constitutional right, and so much so there are two kinds of countries: the countries which have engrafted provision for the protection and improvement of environment, and there are countries which confers right to environment as a fundamental right. And after having that kind of a perusal, what Armin Rosenkranz has remarked, that Indian constitution is one of the most rarest constitution containing the clause of protection and as well as in improvement. So Article 48A envisages that a state shall endeavor to protect and improve the environment. And then two more things have been mentioned, that forest and wildlife. Why it has been mentioned? Because the concurrent list, from a state list to concurrent list, 42nd constitutional amendment has brought into the concurrent list, and where the center have been empowered, parliament has the legislative authority to make national law on forest and wildlife, and the confidence which was reposed to the state in matters of lawmaking was withdrawn in 1976. That's why these two words have inserted here, and now the article read that the state shall endeavor to protect and improve the environment and to safeguard the forest and wildlife of the country, where there is a responsibility on the state in relation to the environment, and appears to be one of the rarest constitution in the world to contain the protection and as well as the improvement clause. On the other hand, we find that there is an insertion of the fundamental duty, chapter 4th A into the Constitution of India, and Article 51 AG says, envisages, enumerate that every citizen shall be under a duty to protect and improve. Protect and improve is the same as it is there, but what is the difference between in let me read first that Article 51 AG says that every citizen shall be under a duty to protect and improve the natural environment, including forests, lakes, rivers, and wildlife, and to have compassion to living creature. So, on an analysis, we can say, that Article 48A and 51AG together underscores environment protection as a most professed constitutional objective, and then it binds all organs of the state and citizen to preserve the natural environment. And in judicial sphere, if we talk of, then this mandate requires court to address environment and ecological question very actively, and then the court must not dismiss nor such issues as mere policy matter, but ensure mere policy matter and non-justiciable matter. Rather, the court must not dismiss such issues as mere policy matter, meaning thereby non-justiciable matter, but ensure the relevant considerations are upheld and and then try to foster environmental justice in this country. How it can be fostering that Article 32, that we will be discussing later, that how Article 32 and 226 being the mandate of the court after the pronouncement and insertion of Article 48A and 51AG, it has given a kind of a fillip. But here we will just compare and contrast. What we can compare and contrast, that protection and improvement is mentioned under both the article, but in matters of Article 48A, it is only the protection of environment, whereas in matter of Article 51AG, it is mention of natural environment, as it has been mentioned here, that natural environment is mentioned here. So this is one of the difference which we can understand, although the people argue that both are the mirror image, but both are not mirror image, and except the difference that one is cast upon the state, another is cast upon the citizen, but both have its own ambit and scope. And if we compare the ambit and scope of both the article, we find the Article 51AG has much more wider scope, in the sense the word natural environment is there. Another thing is that in under Article 48A, forest and wildlife is mentioned, whereas if we delete forest and wildlife, then we find that river and lakes were mentioned in the context of lakes, and rivers is mentioned in the context of Article 51AG, which was not mentioned in reference to what we call is the state, or Article 48A. And the last part is to have compassion for the living creature is something very important, and that compassion aspect talks about it takes the entire question of environment from environment to environmentalism, because compassion is not a subject of law. Compassion is a subject of ethics. Compassion is a subject. Compassion, kindness, benevolence are 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 something which is not a legal duty, but it is a kind of a moral duty. So what we see, that compassion for the living creature, it has been mentioned in the context of the citizen and not in the context of the state. So a compare and contrast of both the articles appears to be something giving that the Constitution of India has a more rights, or here the right is not coming, but what we can say, the Constitution of India have an state citizen participation into environmental stewardship, and it goes beyond protection to improvement, goes from environment to environmentalism, and then it tries to foster more on it environment as a trust on the part of the state, and from the part of the citizen it is a duty. So the trusteeship and the duty emerges from the constitutional edifice of the Constitution of India, which has been inserted into Constitution 42nd Amendment. So we can now say and conclude that the Constitution of India, being as one of the most fundamental document in this country, which exercises its jurisdiction to 1/5 of the population of the world, can have its environmental policy, law, rights, governance, and environmental justice to a great extent under the very foundation of Article 48A and 51AG, which are very salubrious provision of the Constitution of India. With this, we end up the entire constitutional question, or our lecture on environment protection under Indian Constitution. And with this, I thank and I wish you a happy learning.